Welcome to Registry Matters, an independent production. Our opinions are our own. We're so thankful for the support of our patrons. You make what we do here possible. Together, we explore important topics every week. And always remember, FYP.
Recording live from FYP Studios East and West, transmitting across the internet. This is episode 366 of Registry Matters. Larry, did you close your garage door?
I did not.
Did you just leave it open and say screw it?
Yeah, nobody seems to bother anything, so I said, why bother without wasting all that electricity to open and shut it?
Do you think your neighbors just think you're like batshit crazy so they don't mess with you?
I think that's a good possibility. They would think so.
Do you do that on purpose?
Absolutely.
All right. Well, please remember to show your support by hitting the like, subscribe button, follow button, I guess I said that already, and leave reviews in your podcast app. And if you wanted to be so very generous, you could become a patron for as little as $1 a month, and then you could hang out with the dozen or so people hanging out with us tonight in Discord, listening to us record this live, which I don't know how else you would record it. Could you record it dead, perhaps?
I've always wondered about that, recording live. Generally, that most people are alive.
I maybe just before a live studio audience, instead of like, what was the canned laughter thing? The Brady Bunch had that, like, bad.
So I've always wondered how you get a haircut while you wait. I mean, very few people leave their head behind and come back and pick it up later.
That's true. Interesting point. Because, I mean, you would drop off your car to be serviced, but how could you get a haircut not while you wait, right?
I know what they mean. You wait without an appointment, but it seems so weird when you say haircut while you wait. Well, most people do wait while they're getting a haircut.
That's true. All right. Well, tell us what we're doing tonight before we go completely off the rails.
Well, we've got a couple of cases from the United States Court of Appeals. One's from the Third Circuit, and it's favorable. It's not directly on point, but indirectly it is. And then we have one from the Sixth Circuit that's not so favorable. And then we have a shorter segment regarding Senate Bill 82, which is pending in Florida, and it's something that's much more in your area of expertise than mine. So I can't begin to analyze it, but I can tell you, if you ask me some softball questions, what I think, but most of the stuff I don't even understand what I'm reading. So that's what we're doing. We got two appellate cases to look over, and we've got a proposal in Florida that one of our supporters reached out and said this is dreadful, and all life as we know it is going to end if we don't talk about this and build some opposition.
Fantastic. Well, let's dive right into this. And this this is the Florida's Artificial Intelligence Bill of Rights. And Larry, what do you know about anything artificial intelligence?
I know that people are moving towards using that for their daily lives, including me, not as much as others. And I know that people are convinced that it's the demise of all jobs as we know it, as they exist today. And I don't believe any of that to be the case, because that's what they've claimed about all things that are technological, where the Industrial Revolution was going to eliminate people are going to starve to death when they moved off the farms. And all these things are usually overblown. But I know that artificial intelligence has evolved immensely, and I know that people are using it in their daily lives. And we even use it to some degree for some of the announcements you hear, and we use it for voice-to-text recognition, trying to produce some summaries of things. So yes, it is in use, but I don't know much more about it than that.
All right. Well, I located this story by Michelle Vecerina, I guess is what it'd be. Vecerina, Vecerina. It was published on the 21st, so just 10-ish or so days ago. And it says, a sweeping artificial intelligence Bill of Rights designed to protect minors and consumer privacy cleared its first Senate committee Wednesday with bipartisan support. The proposal establishes a comprehensive regulatory framework intended to safeguard Floridians' privacy and digital autonomy while placing strict guardrails on the use of artificial intelligence by minors and government entities.
Well, now you've said a mouthful. Now tell us what does this bill do? Because I can't make heads or tails. What does it do?
All right, so here are some bullet points. Protections for minors. Prohibits minors from creating accounts on companion chatbot platforms without explicit parental consent and requires platforms to provide parents with tools to monitor interactions, set time limits, and receive alerts regarding self-harm or intent to harm others.
What is a companion chatbot?
That would be the only one. Somebody on Narsal Connections for a while it's called Replica, and it's spelled with a K, so Replika, I think is what it is. And you talk to it just like you and I talk on the phone, but obviously you're texting. So, but you're like, hey, how are you today? I'm doing great. And you're talking to an AI. But Larry, the difference with this is there's always some kind, at least in my opinion, everybody uses it how they want to use it, but you design the person, the character that you're going to interact with, and it's always related around sex, Larry. It's always related around sex.
Well, I heard on the show, the name's escaping me, that replaced Dan Bongino, but I heard him talking about someone had fallen in love with a chatbot.
Yep.
And it was breaking his heart what he was hearing. Now I can't understand how a chatbot would break your heart. How does it do that?
Well, they're very sycophantish in that they want to. I don't want to use terms that make them autonomous, like they're an actual entity, but whatever. They are coded and programmed to please you. How are you today? Everything is great. Or I'm feeling lousy today. Oh, that's really a shame. I hope you feel better. They're always like trying to encourage and please you at whatever direction you're trying to go. Up to the point, Larry, that I have not experienced this, that if you start talking about suicidal thoughts, they will encourage you to take suicidal actions.
Alrighty then. Okay, keep going. So
if
I'm thinking of offing myself, don't talk to a chatbot about it.
Yeah, I mean, it's like I don't know how those things get put in place, but it's like, I am thinking about, putting something on my arm to make me bleed out. Like, that sounds like a fabulous idea. You should go get the biggest knife in your kitchen drawer. Like, alrighty then. Thank you for the suggestion. So mandatory AI disclosures requires bot operators to notify users at the beginning of an interaction and every hour thereafter through a pop-up message that they are communicating with an AI rather than a human. These things are really convincing, Larry. Excuse me, that do you know what the Turing test is?
No.
This is an ancient thing, and I think it goes back hundreds and hundreds of years of can a reasonably intelligent person detect whether the system that they're interacting with is either a human or a computer? And I don't think you got a shot in hell anymore, especially with the more advanced ones, that you have no idea that you are you have no idea that you are talking to a computer. They are very convincing. Obviously, grammar is perfect. They can remember things that you talked about yesterday, day before, etc. Like, you have no idea that you're talking to an AI.
Okay.
So this is going to then pop up and remind you that you are not speaking with a human being.
Okay.
All right. Data privacy prohibits AI technology companies from selling or sharing a user's personal information unless it is fully de-identified. I'm sure you can get that one.
De-identified.
Yeah, so anonymized would be a better way to word that.
All right.
Name, image, and likeness protections amends state law to prohibit the unauthorized commercial use of an individual's name, image, or likeness created through generative AI without express consent. Do you know that, like, when you sign up on Facebook, they will put pictures of people, like, sort of tangentially related to you, like, friends of you, and they'll say, like, hey, Andy wants to be friends with you on Facebook. And you're like, how did they get that information? And extend that out to make it where they're generating fake people using your image and populating that about.
Okay, keep going.
All right. Foreign influence restrictions bar state and local governmental entities from contracting for AI technology, software, or products with companies tied to foreign countries of concern, including, of course, China and Russia. I mean, like, okay.
Now you
That would
pronounce
be
that
more up your alley than mine.
you pronounce that like some individual that I'm familiar with.
Yes, I understand that. Do you want to expand on why would that be such a big deal? Look, bar state and local governmental entities from contracting for AI technology. So that means Florida companies cannot use a software product from China or Russia?
That's what it appears to mean to me anyway.
Okay. Yeah, let's make ourselves more isolationist. Perfect. All right, enforcement authority grants the Department of Legal Affairs rulemaking and enforcement authority, allowing for civil penalties of up to $50,000 per violation under the Florida Deceptive and Unfair Trade Practices Act. Whatever. Okay.
Well, you've done a good job telling me the bullet points, but let's talk about the political side. The sponsors are Republican Senator Tom Leek. An identical bill is introduced in the House. They do that dual system of running one in each chamber. Is being carried by Republican Alex Rizzo. And during Wednesday's committee meeting, in closing, Senator Leek said the bill is predominantly about protecting Florida children and vulnerable adults as well as consumers. He went on to say, I believe we have to act. In fact, I think it's morally correct to act to protect these children. Now that's all those are always good buzzwords. If you do
It's
that, it's
always
hard
about
to,
the children.
you have to vote yes. If you vote no on something that's protecting the children, you're asking to end your political career.
Democratic Senator Carlos Guillermo Smith spoke in support of the bill during debate and thanked Leek for bringing the legislation forward. I think this AI Bill of Rights is strong and a necessary first step. It recognizes that innovation and individual rights can go hand in hand. The bill embraces the opportunity that come from AI while also drawing very clear lines to protect our privacy, our dignity, and basic fairness.
Okie dokie. And the next steps, the bill passed through the Senate Commerce and Tourism Committee on a unanimous 10-0 vote, and it has one more Senate committee left before it would go to the Senate floor. Folks, if it passes, I don't know if it's good or bad, but if it passes the other committee, it's going to pass unanimously, not if, but if it passes the other committee unanimously, it's going to pass the floor unanimously. So it's headed to the House, and the House bill, if it's moving, it's going to head to the Senate. And so this is whatever it is, good or bad, it's going to become law in Florida.
The person who contacted us stated the following: we are facing an authoritarian drift where structural checks on executive power are being replaced by high-tech efficiency. I have a full briefing package mapping these statutory handshakes, and I'm seeking to support amicus briefs or legislative testimony to stop this before the March 13th deadline.
Now that was a confusing thing to me because the briefs he's talking about are not a part of the legislative process. That's a judicial thing. And I don't know what the March 13th deadline is unless it's a crossover date. If Florida has a crossover date that if the bill doesn't cross over, it dies. But folks, crossover dates don't mean anything. They're legitimate workarounds for a crossover date. But that may be what it's talking about, the March 13th deadline. So it may have to cross over to the House or it dies.
Wait a minute, stop. Tell me about, did you say workarounds? Legitimate workarounds to crossover days?
Yes, absolutely.
I thought
legitimate workarounds.
I thought the whole idea was to just make it stop and gum it up so it doesn't cross over, and then you're done. What would be a way to bypass that?
Well, every piece of legislation until it's passed in its final form, it can be amended both in committees and on the floor.
Right.
So hypothetically, if there's a bill that's already crossed over from the Senate and neither the House bill, remember the identical bill that was introduced in the House, if it's bogged down in the House and this didn't cross over, all you would need to do would be take this bill to something that has already crossed over and offer it as an amendment in the House side. And if it's adopted as an amendment, it becomes a part of that legislation. Kind of like what happened with the Texas law where they were giving the small towns the same
home
power.
Rule, right?
Yes. And they thought they had cut a fat hog because they killed it. But then there was an amendment attached to a bill that already crossed over, giving them the small towns the same power that the big cities have. And so there's a workaround. If they really want to pass it, if the will's there, they can pass it.
I see. And this whole thing about protecting the children is just, they talk about something similar with encryption and having secure messaging about, and it's, oh my God, we have to be able to see whatever anybody is sending because someone's going to try and talk to a child, and if it's encrypted, then we won't be able to see who said what, when, and all that. And so it's all about protecting the children's. Garbage.
It's hard to
I don't
vote
see how
no.
you. I don't see how you really put forth anything that like actually does anything for this. Because suppose somebody is out of state. If the company is out of state, then they don't have to follow Florida's rules.
Or do they?
Well, or do they? I don't know. It doesn't
I
seem
think-
like if your company is in San Jose, California, Floridians don't have to follow. Well, they don't have to follow the Florida rules.
So, well, we'll find out. Now, I don't know if this is even tangentially enough related to what we do.
It
You
is.
have far more expertise than I do. But if you are interested in this, I can reach out to the sender, and we could get information and maybe even have a guest appearance. But I don't know anything, so you'd have to drive the bus.
Sure. I have deep interest in it because it doesn't take a lot. You heard the voice cloning that I was messing around with during the week, and that was just running on my computer, Larry. I didn't go out and pay for any services. And I think that final one that I sent you was pretty solid. I thought.
It was very good. It was way better than the first version.
Of course. I didn't add any like pauses, ums, or anything. It was just like straight script reading out of Wikipedia practically. So anyhow, let's move along. We got this thing from the United States Third Circuit Court of Appeals, and this is good news. In fact, the press release was issued by the Pennsylvania Association for Rational Sexual Offense Laws, also known as PARSOL. The title of the email was is PARSOL applauds Third Circuit victory protecting fair chance hiring in Pennsylvania. The opening paragraph states, the Pennsylvania Association, PARSOL, celebrates a major legal victory for workers with criminal records following yesterday's decision by the U.S. Court of Appeals for the Third Circuit in FAF. Would you call that FAF?
I would.
Okay, FAF versus Central Transport LLC. The court reversed the district court's dismissal and held that Pennsylvania's Criminal History Record Information Act, or CHRIA, C-H-R-I-A, CHRIA, protects job applicants even when an employer learns about a past conviction directly from the applicant rather from a state criminal records file. Now, this is positive news. What is this case about?
Well, Central Transport rejected Mr. Fath for a truck driving job after he disclosed a 15-year-old armed robbery conviction, despite his commercial driver's license, relevant experience, and federal port clearance, which I don't know what that is, but I'm assuming it requires some kind of security check. We wouldn't want people coming into our ports that we didn't know anything about. The Third Circuit's decision means that CHRIA, his claim, may now proceed, and it sends a strong signal to employers across Pennsylvania and the entire Third Circuit that they must comply with CHRIA's substantive and notice requirements whenever they rely on an applicant's criminal history, regardless of how that information is obtained.
So this does have to be considered positive news if you don't have to, if that helps you get a job, even if you have a conviction, right?
Oh, indeed it is. Parcel Managing Director John Dahl wrote, quote, "We are deeply invested in ensuring that individuals with criminal records are afforded fair opportunities for employment and reintegration into society, and our interests align with Pennsylvania's longstanding policy to avoid unwarranted stigmatization and unreasonable restrictions on those with criminal histories." That's a nice quote.
Yeah, and according to the news release, the Third Circuit emphasized that job hunting is never easy. Having a criminal conviction makes it so much harder, and confirmed that CHRIA limits limits how, when and how employers may use an applicant's criminal history. The panel concluded that Central Transport could not avoid CHRIA's requirements simply because it received information about Rodney Fath's 15-year-old robbery conviction from him during the hiring process, rather than through a background check. Parcel stated, This outcome directly aligns with the position advanced in an amicus brief joined by Parsol and more than 15 other nonprofit organizations led by the National Employment Law Project, NELP, and litigated by Uten and Goldenberg LLP. The amici urged the court to reject a narrow reading of CHRIA that would have allowed employers to sidestep the law's protection simply by asking applicants to self-disclose their records instead of obtaining them from a state agency.
And now let's dissect that last sentence, make sure I understand it. Read it again and explain it so I can understand. Remember, I'm a high school dropout.
All right, so the amici urged the court to reject a narrow reading of CHRIA that would have allowed employers to sidestep the law's protection simply by asking applicants to self-disclose their records instead of obtaining them from a state agency.
Oh, I think I understand it now. They were getting around to check the box. They were saying, well, we didn't. It wasn't because they checked the box. They told us. Okay, now I understand. The amicus brief detailed how millions of Pennsylvanians live with criminal records and face steep barriers to work. They're often unrelated to their ability to safely and successfully perform a job. It also highlighted Pennsylvania's longstanding policy rooted in state constitutional principles that disfavors blanket employment exclusions based on prior convictions and instead requires that any consideration of a conviction be tied to the actual duties of the job. Now, gee, that kind of makes sense. CHRIA codifies that policy by allowing employers to consider felony and misdemeanor convictions only to the extent that they relate to the applicant's suitability for the specific position and by requiring written notice when criminal history is used to deny employment. I bet they're going to carve out PFRs. What do you
think
bet?
so?
I bet they do.
Well, interesting. All right. So that, but yeah, okay. I get it. That's good. This is good news.
I'd say it's really good news in terms of the people who are looking for jobs, because check the box. I mean, we were hard pressed to get that passed here, and we finally did ban the box. But that doesn't ban them from saying we can't hire you because of this conviction. If they didn't get it on the box, as long as they got it some other place, they said, well, we still want to know about it. So I can see that this would be helpful.
Yeah, I get you. Totally get you.
You're banning the box, but that doesn't ban the discrimination. This is going a step towards banning the outright discrimination.
Sure. God, I mean, at 15 years, like how, there's got to be some kind of line, Larry. Obviously, if like 1 year ago, it would have a lot of relevance. 5 years, obviously less. 15 years ago, like, are you the same person?
So, well, we are not very good about forgiving in this land of forgiveness.
We are not. We are not very good about it at all.
We claim we believe in that, and I mean, it's Judeo-Christian principles, at least Christian principles I heard all my life. But it's amazing that in the Bible Belt, where they talk about those Christian principles so much, they seem to be the most harsh about being unforgiving. I mean, isn't that funny?
Fire and brimstone, baby. Old Testament world down there.
Mm-hmm.
Nuke your whole family and everybody up and down, just, like the flood. Let's just do it that way. Plagues, all that.
Makes sense to me.
Perfect.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
Well, let's talk about this case from Kentucky. Should I talk like Turtlehead?
Who's that?
Never mind. It's an appeal from the United States District Court for the Western District of Kentucky. The name of the case is John Doe. God, there's so many John Does out there, Larry. And on behalf of himself and others so situated versus John Burlew is his name. In his official capacity as Daviess County, Kentucky attorney, and on behalf of all county attorneys in their official capacities. Did we win?
Not exactly, no.
Should I play the womp womp sound?
No, we didn't exactly win, but we haven't lost either.
All right, well, okay, so that's kind of an evasive answer. So what does that mean? I was reading on the first page and something jumped out at me immediately, and Circuit Judge Murphy said, this case shows the cost that litigants impose on themselves when they pursue only facial constitutional claims. Now, he cited Moody versus Net Choice, LLC, 603 U.S. 707, 723, and that's from 2024. I've heard you talk about since we started this program that facial challenges are really risky. Why is that?
Well, because to prevail on a facial challenge, the legal standard is quite tough. The challengers must meet they must meet the standard as follows, that there are no set of circumstances where the Challenge Act could be constitutional. And I tell folks, when you start challenging the registry, saying facially you can't register people, that's where you go wrong. There are dozens of situations where I could design a constitutional registry. We just haven't done it, but I could. And we have registries that operate quite within the constitutional framework. So you have also heard me pontificate that almost anything can be done if the act is narrowly tailored to an individual rather than to an entire class of people. Also, the restriction must be no greater than necessary to achieve the purported purpose of the restriction. Victims, advocates, law enforcement, please listen. You can do almost anything if you'll stop painting with a broad brush. Try to learn from FYP education. That's what we're here for.
You are so generous, Larry, giving away that advice for free.
Well, I do. I try to help the phone scammers. I try to help them be better scammers.
All right, let me set up the case, please. Before that, Kentucky passed a law requiring covered PFRs to put their legal names on their qualifying social media accounts. John Doe, a covered PFR, sought to have the statute declared unconstitutional and moved for a preliminary injunction. He argued that the law violated the First Amendment because it barred regulated parties from speaking anonymously online. Yet he did not attempt to enjoin the law as applied to any specific speech or any specific social media account. Rather, he sought broad relief by arguing that the law was facially overbroad. Although the district court agreed with Doe, it did not engage in the demanding comprehensive review that a facial challenge requires.
Yes, and that is true. And they also said, like the Supreme Court in Net Choice, we vacate the court's injunction and remand for further proceedings. So that was the big cost they paid. This case has been set back for years.
Now tell me something. Do you know what the origin of this law is?
I think I do, but the court explained it better than I could. They said at a legislative hearing in early 2024, a Kentucky state senator recalled a conversation that she had had with a constituent about a loophole in Kentucky's PFR registration laws. Now, you also heard me say that through the years, that most of the time they don't dream this stuff up. It's brought to them by advocates or individuals. While the constituent was planning an event for children, an anonymous man reached out on social media asking about whether his business could participate. The constituent discovered only through additional research that Kentucky had placed this man on its PFR registry. The senator introduced Senate Bill 249 to close this gaping loophole by requiring PFRs to use their legal names on social media. Within months of this hearing, the Kentucky legislature unanimously passed the bill. Now, there are at least 2 Democrats in the legislature in Kentucky, and the governor,
probably a maximum, not at least a maximum.
And the governor signed it into law, and it's known as Kentucky Revised Statute 17.544.
As I understand it, Kentucky law now prohibits a registrant who has committed a criminal offense against a victim who is a minor from creating or having control of an account on social media platform unless the account displays his or her full legal name. The law defines the phrase criminal offense against a victim who is a minor to include over a dozen crimes, including, for example, kidnapping, unlawful imprisonment, human trafficking involving commercial sexual activity, and sexual abuse, so long as the victim of these crimes was under the age of 18.
It's a very comprehensive list for sure. It doesn't sound like much narrow tailoring has occurred, but they just can't help themselves, can they?
That it sounds like it. The law also contains an extended definition of the types of social media platforms that do and do not trigger its disclosure duties. On the one hand, the definition covers a website or application that is open to the public. Like, if it's a website and it's not open to the public, who would use it? All right, so an application that is open to the public. I mean, Facebook is behind at least a login prompt, so whatever. All right, and allows the user to create an account and enables users to, among other things, interact socially with other users on the website or in the app, share a social connection with other users, and create or post content viewable by others. On the other hand, it excludes a broadband internet access service, an email account, a search engine, a cloud storage or cloud computing service, a service in which interaction between users is limited to reviewing products offered for sale or commenting on other users' reviews, and a website that consists primarily of a provider's own selected content, even if readers may chat or post comments about this content. That's complicated. Now, I thought you said that laws must be drafted with clarity where a person of ordinary intelligence can comply. I feel that I am like a teeny bit above average, and that's complicated.
It's definitely far above my ability to understand. And I think if I had been in the mix on this planning of this lawsuit, I would have raised that as one of the challenges, because I accept the fact that they can limit a small group of PFRs. Perhaps the people that brought this case do not accept that fact, but there would be constraints you could put justifiably and constitutionally. But I would have brought that in to try to narrow the focus of this law, because if I can hammer you down on who you can apply it to, and I can hammer you down on how you've drafted it and force you to put more concise and understandable language, I've won. And remember what I'm here for. I think you've got a clip for that.
Oh, I do. If right here.
Trying to win the game.
I'm sorry, what?
Trying to win the game.
Right. Trying to win the game. I mean, so one of my problems with something like this, Larry, is that there is one, I'm sure you're familiar with it. It's called LinkedIn.
Yes.
LinkedIn fits all of that criteria. You create an account. It's open to the public. You are supposed to share content content. You are supposed to contact other people. And in this modern world, the way that, and even in the old days, Larry, like the way you get a job is through word of mouth. And this is just a word of mouth amplifier, so to speak, that it doesn't have to be somebody that you saw at the restaurant last week or anything like that. These are people that you've interacted with 5 or 10 years ago, and you now are open to a job, and you put open for work, and there's this banner on your image that says you're open for work, and poof, then you end up with a job. But it's not designed for children's.
So,
and it doesn't really say that, does it?
Not so far. I haven't seen it, no.
I don't think it was in there. It's like if it's social media, if you can create an account and share content. I didn't see anything that is because I don't think that I've ever seen someone under, 20 or 25 on LinkedIn, really. All right. Well, anyway, let's talk about the plaintiff. A state court had previously convicted Doe of multiple child porn offenses when he was 18 years old in 2015. Doe received a 5-year suspended sentence for these crimes and must register for the rest of his life. So the new law applies to him. Since his conviction, though, Doe has lived a law-abiding life. He has not been under any type of criminal supervision for many years. He is also married and has children. Is he a good candidate, do you think?
Probably about as good as we could hope for in this situation. I mean, you're not going to find too many people that this would apply to that sang too loud and quiet on Sunday. So it's probably as good as we could have found. So I don't have any criticism of the plaintiff.
All right. So Doe regularly uses social media, including X, formerly Twitter, and Reddit to obtain news, communicate with friends and family, and comment on other users' content. Well, that fits all those things that we read above. Although he keeps his social media accounts anonymous, he does regularly disclose his prior conviction and status as a PFR. He also states his unpopular political opinion that PFR registration laws do not deter crime and unfairly affect his children. I think that everyone would agree that that is true. Now, when Doe has disclosed his prior crime or stated these opinions, other social media users have harassed him online and threatened him and his family. He has also faced harassment for stated unrelated opinions. Doe fears that the new disclosure duty could lead to severe harm for his wife and children because the PFR laws elsewhere require him to publicly reveal his address. Doe thus plans to deactivate his social media and cease using it altogether rather than put his legal name on the accounts. Yeah, and before you had that wife and kids, you should have thought about that before those crimes.
I think I can agree with that. Should have thought about it in advance.
Do you agree that these fears are justified?
Actually, I very much agree with these. I don't understand how it would be complicated. But again, I know that there are thousands of legislators listening. If you had just narrowed this down to websites that are primarily accessed by minors, and I don't have the exact language because I'm thinking on the fly, but if you tried to narrow it down, and if you tried to narrow it down to people who had very recent offenses, and maybe put some kind of objective criteria that they could jump through without a whole lot of jumping to show that they're beyond that, that's no longer who they are, you could do this.
Sure.
But you just can't help yourself. You fall into the trap of wanting to please a constituent and make a name for yourself and say, I passed a bill, have it to put on your campaign literature that you got the toughest social media law in the United States. That's what they're doing here.
Let me ask you a question in your opinion as like a bill writer. And I know that you're not super tech savvy in this regard, but I go on Reddit pretty regularly. And I have my own little curated list of, they're called subreddits. And God, I was talking to my kid the other day and I was like, I probably have 50. And no, I've got like 200 things that I follow. From things like I have some storage, network attached storage in my basement. So I am part of that subgroup. I do follow the sex offender support one, and on and on and on. I rarely post, Larry. And forget that I rarely post, but even if I did, I have no idea who I am talking to. The person on the other end that I happen to be very rarely replying to, they could be 12, they could be 120. No clue. I rarely even look at their screen name to see who they are presenting themselves as. But as far as where I'm going with this, though, is if a handler wants to look at what I am interacting with, they could see the channels that I am a part of and determine whether I am going after children-oriented content, that I am engaging in adult-oriented conversations and content to either help me professionally or, get better at life or whatever the hell those things are. There's get disciplined and so forth, trying to improve health and exercise and professional. Why would that? Is that too much to ask for?
Well, yeah, but see, that's when you have a handler. He no longer has a handler, as you no longer have a handler.
Well, sure, but he is still on the registry because he's going to be on that for life.
But he doesn't have a handler that can come to his house and search his browsing history and do those type of things.
So just the state sheriff's office, whoever, the state police, those are the ones that are handling him now, so to speak, just making sure that he's following the rules of living restrictions.
Yes, and also they would probably be looking for social media to see if they can find where he's not complying so they can make a case. But he has a lot more leeway to do things when he's not being supervised directly.
And because of that, he then has his Fourth Amendment protections. They can't just do random searches and seizures like someone on supervision does.
That's correct. And also they will ask you. I've heard people that are merely on the registry saying that they've been asked to consent to searches, and some of them do. And I tell them you don't have to, but I'm not going to tell you don't do it, because if you don't, things can go south. So you have to make your own personal decision. But yes, they would have to have some justification by a court to come in and search your computer and seize anything.
Interesting. Okay. All right. Well, and I recall that you are very much not a fan of class action lawsuits. So let me read from the opinion. It says, shortly after suing, Doe moved for a preliminary injunction and for certification of a class action under Federal Rule of Civil Procedure 23. The district court resolved these two motions in two opinions. The court first considered the injunction request. It found that Doe would likely succeed on his claim that the law infringed on his First Amendment right to post anonymously and was overbroad because it regulated all social media speech. Well, that sounds like a win. The court also concluded that it could grant class-wide relief even before ruling on Doe's motion to certify a class. So it granted a preliminary injunction that barred Burlew and all county attorneys from enforcing the disclosure law against anyone. And then the trial judge held class-wide relief could be granted before he ruled on class certification. What did he decide on that question?
The court first held that being the district judge, the trial judge, that Doe lacked standing to serve as a class representative for absent class members against any county attorney other than the Burlew County attorney. It then held that Doe could not pursue a class action against Burlew because he failed to show that absent class members were too numerous to join in a single suit. In other words, they didn't do their homework in advance.
Okay.
And that the counsel who was representing him could adequately represent a class of people. And in a class action, the legal team has a duty to represent and communicate with all class members. It's very difficult for a solo practitioner to meet that high standard. You've got to have bank. You've got to have resources. You've got to be able to reach out. You may have to do mail. You have to build a website. You have to do a lot of things so you can communicate with a large class. It's very hard for a solo practitioner working in their basement to have those type of resources.
So what it sounds like to me is that this has a negative impact on the case. Did it?
It did. The court's decision to deny class certification led to it led the court to narrow its preliminary injunction. It limited the preliminary injunction to cover only Burlew and not any other county attorneys and protect only Doe, not any other class members. So it was a very narrow thing.
Do you mind if we circle back on facial versus an as-applied constitutional challenge? Would you explain what that all means? Can you dumb that down especially for me?
I can do it, but the court did it even better. They explained it very well. They said, these claims differ in the showing of unconstitutionality that a challenger must make to succeed. An as-applied claim requires a challenger to show only that the law violates the Constitution as applied to the specific conduct that the challenger seeks to undertake. On the other hand, a facial claim requires a challenger to show that the law violates the Constitution in a much broader set of fact patterns. This broader theory seeks a holding that the law could never be applied in a valid manner. And that is a really difficult thing. When you're saying there's no registration scheme that could possibly be constitutional, you've lost as soon as you stop speaking.
Sure.
Because the registration scheme could be constitutional. They're not, but they could be. So you've lost before you got out the gate. Now, if you said all African Americans must remain in their homes on Sunday, there would be no set of circumstances where that would be constitutional. So you could raise a facial challenge on that.
Now I recall though. Go. I'm sorry.
And succeed.
Okay. And I recall that we've discussed overbreadth in the context of the First Amendment claims. Now, could you go into that a little bit?
Sure. The Supreme Court's so-called, they invented this, I don't think it's in the Constitution, overbreadth doctrine adopts an easier to meet test under the First Amendment to provide a little bit of breathing room for speech. And they cited Hansen 599 U.S. at 769 to 70. A free speech challenger can succeed on a facial overbreadth challenge by showing that a law prohibits a substantial amount of protected speech as compared to its plainly legitimate sweep. And there was a recent case, 2008, it's almost 20 years ago, U.S. versus Williams, and I cited that in some own litigation. In other words, legislatures cannot obliterate the constitutional protection of free speech with a broad brush to hypothetically protect something very narrow. You've got to narrowly tailor anytime. When you're writing something that's First Amendment, you've got the overbreadth doctrine in addition to facial and as applied. So we can get you with overbreadth if you did something that would be legitimate if you had not been so broad. So folks, listen to what the courts are telling you. Narrow it down. Don't write it overly broad.
So the way that I'm trying to understand this, the way that I'm reading it, seems that the litigants disagreed on whether the challenge was facial or as applied. Is that how that went down? How did the court resolve that disagreement?
Well, they had the same difficulty because the appellants in this case were trying to say, well, no, it's not a facial as applied. But the court looked at two other data points that confirm, and let me just read. They said two other data points confirm we should consider only Doe's facial challenge. For one thing, the district court treated Doe's request for preliminary injunction as raising only a facial claim, seeking a facial remedy. The court thus evaluated Doe's likelihood of success on the merits using the court's overbreadth standards for facial claims under the First Amendment. Finding in Doe's favor, the district court initially granted broad facial relief and joining the law's enforcement as applied to anyone on any social media account. And although the court later limited its relief to Doe when denying Doe's request to certify class action, it still relied on that initial facial analysis. It barred Burlew County from enforcing law against Doe in all circumstances, not just as applied to any specific speech that Doe wished to express anonymously or a specific social media account. They noted Doe has not preserved any as applied challenge in this appeal.
Now, would you remind us what is needed to preserve an issue for appeal?
Well, it's actually more simple than what people make it. An appellate court is not trying the case from scratch. It's looking at what's already been done. And it's not fair to a trial judge for them to act as if they had tried the case themselves, because they didn't. They didn't hear the evidence. They didn't evaluate the witnesses. They didn't do any of those things. So in order for you to raise something on appeal, you need to raise the issue below and provide the trial court with at least an opportunity to rule on the question. Now, the trial court can say, "Counsel, I'm not ruling on that. I'm going to reserve that," and just never rule. But if you've attempted, or you've gotten an adverse ruling from the trial court, then the issue is preserved for appellate review. If you haven't raised it, you can't raise it for the first time on appeal. You can't say, "Whoops, if I'd have been doing my work more thoroughly, I would have thunk of this and I would have done it differently." It doesn't work that way.
And then let's talk about the Supreme Court's decision in net choice for a little bit too.
Well, I know very little about it, but just what I could glean from this. But the case addressed state laws that regulated social media platforms such as Facebook and YouTube. The laws regulated social media companies' content moderation and required the company to send an individual message to a user when restricting the user's content. Two circuit courts had reached different results on whether the laws violated the First Amendment.
Now, I thought that the Supreme Court ruling in Packingham versus North Carolina was sufficient to prevent this from happening.
Well, apparently so did Mr. Doe. But the court had an answer for that. The court stated that Doe's contrary arguments lack merit. He first compares Kentucky law to the North Carolina law found unconstitutional in Packingham. Yet the two laws differ. The North Carolina law in Packingham affirmatively prohibited PFRs from using social media accounts. The Kentucky law merely requires them to disclose their legal names on these accounts. Now, would you admit that that's a significant difference? If you're told you ain't going to go on there, I'm going to lock you up. If they say you can go on there, but if you don't give your name, I'm going to lock you up.
Right. Yeah, that is definitely different.
So the Supreme Court has long viewed disclosure requirements, and this is the court speaking, the Supreme Court has long viewed disclosure requirements like the one in this case as less restrictive on speech than absolute prohibitions like the one in Packingham.
All right. Well, then what happens next?
Well, it's been remanded to the trial court for a new analysis, and this case is going to drag on for a couple more years, possibly more, and we're back to basically almost starting from scratch in the trial court. That's where we are in. It's a shame, but sometimes people try to go for gusto. You have to narrow, and you have to look at what you can win. And like I say, I'm looking at it through the rearview mirror, so I'm gonna try to be fair. I don't know what I would have done if I'd have been in the beginning, but I don't like class actions, and I don't like facial claims. So I would imagine, just from my intuition of not liking either of those, I would have been pushing back.
Let me ask you this, like, just from a practicality point of view. If Doe had just sought relief for him, then his next door neighbor can then use that and go, well, he won and I'm similar. You don't necessarily have to go for class action. Class action to me is like the whole tire thing with the Ford Explorers, when all the tires were exploding and Explorers were rolling over and killing people. Like, that's a class action.
Correct, and you are correct on both accounts. There are cases where a class action is appropriate when the claims are almost identical or so similar that they're difficult to distinguish, and they're so numerous that you would clog the courts. We don't know how numerous. Nothing came up in my reading, and I didn't read it word for word, but nothing came up in terms of how many offenders this is impacting, whether it would crash the court system as we know it, whether or not the cases are all that similar. There was none of that disclosed. If it was, I didn't see it in the case. And so there's when the airbag is prematurely deploying and shrapnel, similar materials hitting you in the face, and your eyes are getting put out, and these things, those are very similar. And it would be if it's happened to 47,000 cars that have been sold in Kentucky, you can fairly succinctly identify the breadth of it and how you wouldn't want 47,000 individual cases moving through the court system. But this is it's like it reminds me a little bit of a case that was initiated on the western part of the United States about IML identifiers.
God, Larry, what are you talking about there, man? I got nothing. I'm just drawing complete blanks. Like the bubble over my head. I'm Rocky and Bullwinkle, and I got the little bubble over my head, and it's got nothing in it.
So that's what this reminds me of. It was a little bit going for the gusto when see I like to win.
What?
I like to win. Everything I do, I like to win. And I would like to have won the case for Mr. Doe because then I could take credit for all the people that come in from the western part of the United States and they come swooping in to do litigation, like happened
Yep.
in another state in the mid part of the country after we did the ice breaking, the original case in
In
Georgia.
Georgia. Yep.
Yeah,
Yep.
that's what I prefer to do. I prefer to keep cases narrow and focused so that you can win and then you can build from the win.
And that we also said at the beginning he was gonna win, right? He was gonna. He had the injunction, and then like they had agreed, they thought it was overbroad, and they were going to apply it elsewhere, right?
Yes. He's still likely to win.
Okay. But then again, still neighbor, whatever, next county over. Like this guy, I'm basically similar. I got similar conditions, and I'm going to have to do this too. And you'd be like, oh, well, yeah, then you win too before you even really do a lot of work.
In
Right.
that case, in that circumstance, if you have a federal court decision that's withstood appeal, like if Doe had won this, if he'd have done an as-applied challenge, and if he had won this without going for the gusto, there could be a whole avalanche of cases that would ensue using the appellate decision. Because I would imagine that Kentucky would have appealed if he'd have just been litigating for himself, because they wouldn't want this precedent to be established.
Right.
So they would have still appealed, but we would have a solid appellate decision.
I'm with you. I understand. Fantastic. Interesting. But so it's sort of like a win with a loss too, because if he still wins, then that still has impact for others. It just isn't everybody wins all at once.
And it's years down the road, possibly 2 to 3 years down the road before this case resolves itself, because it's got to go through the trial court again. The trial judge is going to be very careful. Then the state's going to appeal it, because the trial judge is still going to grant the relief. I think. I don't think this is a losing hand. So he's still going to win, and then it's going to go up on appeal again. And we're going to be waiting and waiting and waiting.
I see.
No telling how many people. No telling how many people are going to get charged for violating this because of the extra 2 or 3 years of delay.
And would you have to have skin in the game that you are like being threatened by the registry people in the state? Would you have to have skin in the game that you're not following it, that you're about to be arrested and all that before you could?
You don't have to wait till arrest is imminent, but you have to be within the plain sweep of the law. So if this applies to you, and remember you read it's a pretty broad, what did they say, 12 categories of offenders?
Yeah.
Yeah, it's pretty broad. But if you fit within one of those, you would have the requisite standing.
Okay, I gotcha. All right. Well, anything before we go?
I have one announcement to make. We are in the midst of a very short legislative session of 30 days. We're almost at the midpoint. We will be at the midpoint Monday. The final 2 weeks, there's a lot of criminal justice garbage in our system this session, and I could very well be in Saturday hearings the next couple of weeks, because they tend to have weekend meetings. Because it's a 30-day constitutional limit. You must adjourn at noon on the 30th day. So I expect I might have some distractions in the next 2 weeks, but we'll keep you posted. Either we're going to record or we won't, but right now. We plan on recording unless I get trapped in legislative stuff, trying to kill bad bills, and we've got a boatload of bad bills this year.
Somebody says, "Is there a third option?"
But I mean, we will let you know if I get trapped where I just can't get out, because I'm
I
really.
know. But you just said we either will or we won't. It's like, well, yeah.
Well, that is really only the two options. But we could record Wednesday night at midnight.
We could.
So,
I will be flexible if you need to be as well. So anyway, with that, head over to registrymatters.co for show notes and links everywhere, and email us at registrymatterscast@gmail.com. Leave an old-fashioned voicemail message at 747-227-4477. And as the folks in live stream chat here have been a part of, they are patrons, and so thank you very much for being that. And you could become one too over at patreon.com/registrymatters. We are independent creators here. We are, this is just kind of like a little part-time job for us, and having more patrons is better than fewer patrons. And even for $1 a month, that is always helpful to bring the numbers up, which is what we're trying to do. And those folks can join on the Discord server. Someone just asked me randomly, he's like, well, how do I get on Discord? Check out the show notes, and you can find a link to it. And that is what we will, and then you can join in the Discord. But also, I'm wearing one of our shirts tonight. Thank you to one of our supporters. I know it doesn't show up on camera so well, so I'm like pulling it up all to my chin and whatnot. But this is an awesome one. This is one of my favorite ones, because this is what you want everyone to say, Larry. Are you looking at the screen by chance?
I am.
It's not punishment. It's a civil regulatory scheme. Beautiful. No one you could wear this to the mall or the food court. No one's going to know what the hell you're talking about. So pick those up at fypeducation.org/shop. Anything else? Any final words?
Nope. We'll see you in the week or
a week or 2 or 3. Have a great night, Larry. I'll talk to you soon.
Good night.
You've been listening to FYP.